Welcome to today's webinar, Restart and Recovery, addressing leave requests, reasonable accommodations, and staff member rights. It's great to be with you today, and I have a wonderful group of co-presenters with me. We knew that this was a complicated set of issues to talk through, but it's a set of issues that all of us are dealing with right now. So very happy to have with me Bob Schwartz, who's the Chief Legal Counsel for NJPSA. Andrew Schwartz, who's legal counsel at NJPSA as well. Sandra Jakes, who is our supervisor of legal research and content development for Legal One. And Rebecca Gold, who is sort of retired, who's a retired director of human resources, an interim director currently, and has done a tremendous amount of work with us on so many of our webinars and in-person trainings. Thank you all for being here today. We're going to be diving into some important issues regarding the Americans with Disabilities Act, thinking through reasonable accommodations and leave requests, issues related to sick leave and other employee rights. As we do that, obviously we're touching on some complex legal issues, and every scenario has its own twist to it. So as we walk through these issues, we're not technically giving legal advice. We are trying to give you the best information available. For those of you who are NJPSA members, of course, we always encourage you to reach out to us for legal advice. And for everyone, you should reach out to legal counsel regarding any particular issues that you might have. So today we're going to walk through some basic challenges that we're all facing. The increasing demand that we know is coming for leave requests, the increasing demand that we know is coming for reasonable accommodations, understanding the Americans with Disabilities Act, understanding other state and federal laws that could be invoked regarding employee rights, understanding how to apply all of these laws to this global pandemic. And as we walk through these issues, we're going to walk through a number of scenarios, because we know this is not the type of issue that you can talk through in theory. We have to talk about sort of real world examples of how all of this would play out. As we talk today, you all do have access and should be able to download the documents that we're using. So we have a guidance document that we have developed to help understand the Americans with Disabilities Act and various leave options. Another guidance document that talks about employee return to work scenarios, a sample form to think through, the kinds of information you would ask employees regarding accommodations or leave requests. And I do want to say these particular documents that we're sharing are the result of ongoing collaboration we have with a number of other education associations. And our hope is that in the very near future, all of the major education groups will be announcing joint guidance on a number of these issues. We're working through that process now because we think it's important that we have a common message regarding these complicated legal issues. So much of the work that you're seeing is work that has come from other associations as well, and some great work that they've put into helping us understand these issues. So of course we are dealing with this age of uncertainty right now, and it's a very difficult time, a very scary time. We've had more than 15,000 deaths in New Jersey linked to the coronavirus, more than 140,000 nationally. There have been spikes in cases in many states in the country, and some states that are very close to us here in New Jersey. The good news is that we, frankly, are doing as well or better than pretty much the entire country. The steps that we have taken in New Jersey have made a real difference. We are doing incredibly well at this point in time, relatively speaking, but large portions of the country are not. So we are in this age of uncertainty, and we know that many of the challenges that we are continuing to deal with could become greater as we look to reopen. So large portions of our staff members have a tremendous amount of fear and concern. Many of our staff members have underlying medical conditions that would put them at higher risk for significant harm were they to contract the coronavirus. The CDC has laid out a set of criteria for identifying staff who would be at enhanced risk of substantial harm if they were to contract the virus. So we're going to walk through that information and how we couple that information regarding those who are at enhanced risk with the rights of employees under the Americans with Disabilities Act and a number of other state and federal laws. Staff members are also very fearful, not only for themselves, of course, but for their families. And staff members could have family members who are dealing with underlying medical conditions who are at greater risk. And we obviously want to be very sensitive to those concerns as well and understand the various rights and leave options that are available to address that particular set of concerns. So we're going to walk through this. We're going to walk through a number of available legal rights and obligations. And as we start our discussion, we certainly want to figure out who are the employees who might be at greater risk. So the CDC is constantly updating its list. They have reviewed data and identified employees who are at increased risk, and then have identified additional criteria that tell us that somebody might be at increased risk, which creates, some real challenges to understand how we deal with those who are in that category. Legal obligations are clear, and we're going to try to walk through those for those who are identified as being at increased risk. It's not quite as clear for those who might be at increased risk, but nevertheless, it's important for us to walk through those issues. So we do embed in today's PowerPoint a link to the CDC criteria, which was last updated June 25th, but could be updated at any point in time. So we always want folks to look for the very latest information. And one point I'll make just here as we're getting started, for those who have read the Road Back, the Department of Education guidance document, and my guess is all of you have, that document included a list of criteria for staff members who might be at increased risk. But frankly, those criteria are somewhat outdated now. It does not include all of the information that we have from the CDC. So what we have included here is the very latest list of those who are at increased risk. It includes persons age 65 or older, or somebody who might have one of the underlying medical conditions that are listed here. And it's a broad set of conditions. You'll notice that one of those is body mass index of 30 or higher. When the Department of Education came out with its guidance document, that number was a body mass index of 40 or higher. So when you get to 30 or higher, you have a large percentage of our population who would meet that criteria. So you've got this list of criteria where the CDC has said as strongly as they can that these individuals are at increased risk of severe illness if they were to contract COVID-19. And then we have a number of additional conditions, a long list of additional conditions for staff members who may be at increased risk. And there is in some cases, there are limited studies, or there's mixed evidence because not all the studies say the same thing, but these are additional folks who might be at increased risk based on certain medical conditions. So even though, again, it's complicated looking through this set of issues, we want you to have the very latest information. Of course, the Americans with Disabilities Act does make it unlawful for us to discriminate against anyone who's a qualified individual with a disability. It outlaws discrimination, whether it's in job assignments, training, leave requests, or benefits. And today we're going to focus very much on the issue of leave requests. So under the Americans with Disabilities Act, a person has a disability if they have a physical or mental impairment that substantially limits a major life activity. It also protects individuals who have a record of or are regarded as having a substantially limiting impairment. And it provides protection, if there's a substantial impairment of a major life activity. And if you look at that list, it is a very broad set of activities that are considered major life activities. And obviously, many of those activities would be invoked if somebody is in the workplace in a school. One of the legal issues to think through here is the issue of what do we mean by a substantial limitation. So typically that involves a condition that's permanent or something that's likely to extend for more than 6 months. And there was some thought that that was a hard and fast rule. But we have a decision from the Third Circuit Court of Appeals that just came down very recently, May 29th of this year, making clear that sometimes you can have a disability that is a temporary condition, but if it's sufficiently severe, you could still qualify for protection under the Americans with Disabilities Act. So that 6-month rule is not a hard and fast rule. You also have to consider the severity of the condition in question. If you have an individual who does have a qualifying condition, now the school district, if they become aware that somebody has one of these qualifying disabilities, there is a legal obligation to provide a reasonable accommodation in the workplace. And we're going to focus very much on that today, and what that might mean, when we might have to provide those reasonable accommodations, how we balance that with some other challenging issues. So obviously a reasonable accommodation in some cases may include somebody working virtually. In many other cases, it would include restructuring the job, modifying a schedule, changing the level of protection that somebody is provided in their role. So employers are required to engage in what we call an interactive process that we'll walk through in a moment. And they are required to sit down and work with the employee to consider reasonable accommodations. There are times where it would create an undue hardship for the employer, and the reasonable accommodation that is being asked for cannot be provided, or it might not be possible to provide any reasonable accommodation. So if it would be unduly costly, if it's too extensive, if it's too disruptive to the workplace, or if it fundamentally alters the nature or operation of the business, that would be considered an undue hardship. And we will walk through some of those issues. So how does the employer determine if a reasonable accommodation is appropriate? The requirement is generally triggered by a request from the employee. You're not going to know that somebody has an underlying medical condition that puts them at enhanced risk unless they come forward and ask for a reasonable accommodation. So the employer obligation also applies if the disability is obvious. So we, for example, have seen cases where the employee uses a wheelchair and the employer says you're going to have to work on the 4th floor, and it doesn't matter that we don't have an elevator and you can't get there. That's an obvious disability, and the employer should be working to provide a reasonable accommodation in that case, even if the employee didn't come out and say, hey, I have a disability. You can see that the person is in the wheelchair. So we have an obligation to enter into an interactive process to determine if a requested accommodation is reasonable. And courts do consider in trying to figure out if something is reasonable, is it effective? Does it actually do what we're trying to do? Does it permit the employee to perform the essential functions of the position and address their disability? When we're thinking about this process, you want to utilize the consistent employee disability accommodation request form. You shouldn't have each building doing their own thing. There should be a uniform district-wide process working through your human resources department. You should be requesting a physician certification of disability and or the fact that somebody's in a high risk category. And this gets a little complicated because you're not entitled to know somebody's medical diagnosis under HIPAA. You are entitled to know that the person, for example, has an underlying medical condition that puts that person at higher risk. So you're entitled to some level of information, but not the specific diagnosis. An employee might choose to share the specific diagnosis, but they are not required to. So we enter this interactive process.
David, can I ask you a
Go ahead, Bob.
question? We agree that the diagnosis doesn't have to be provided. But if you submit a note, and it's a generalized note, for example, somebody submits a note and says that due to underlying health conditions, I need an accommodation, and the accommodation that I'm seeking is to work virtually. How specific does the information, if the district's not satisfied with that, how specific does the information have to come to in order for it to serve as a basis for the board to provide an accommodation?
Yeah, great question. So we have a sample form that's an accommodation or leave request form, and it has some good questions on it. So if the employer was to ask the employee to put in writing, what, if any, job functions are you having difficulty performing? So you get the person to articulate what it is that makes it difficult for them to do the job. How does your disability affect the essential functions of your job? So those are the kinds of questions that you want to ask, and then get the person to, articulate. Let's say they just have an underlying medical condition. They are obese and have a BMI of 40. So the person would be articulating they have an underlying medical condition that is on the CDC list that puts them at higher risk of exposure or of severe reaction to COVID-19. Of course, now the next question is, what accommodation are you asking?
Is the district entitled to ask which one of those items on the CDC list you have?
They're not, but if they're skeptical, right? And sometimes employers don't always trust the information they're getting from the employee. You could end up going through a process where somebody has to have an independent medical examination. The two parties agree on a doctor. The employee goes to that doctor, and the doctor confirms that, yes, this person has one of those underlying medical conditions that would qualify them for reasonable accommodation. And now you're satisfied that the person's not just making up something that may or may not be on the list.
What if the district's doctor, David, disagrees with the individual's doctor?
Yeah, that's where you end up sort of agreeing on a neutral doctor to provide an additional medical examination, and you end up with an independent medical examination. And then you could have litigation when the parties all disagree. Right? But before you get to the litigation point, you'd want to have an independent medical examination and see if you can just reach a common understanding about whether the condition exists or not. And that's only the first part of the analysis, right? You have to figure out, does the condition exist? What reasonable accommodation are you asking for? And if you're asking for, stay home and work from home, we'll use a simple example. Somebody is a custodian in the building, right? And there's really no situation where you could reasonably accommodate that custodian and have that person working from home. In many cases, we can find a way to accommodate a teacher to be able to instruct virtually. So you have to figure out, what is the accommodation that's being requested? Can we provide it? So if someone has an underlying medical condition and you can figure out how to reduce the risk for that person, that could be what the employer offers. We'll give you enhanced PPE. We'll put in these additional precautions so that you're interacting with less people, or you've got a staggered schedule that has you interacting with less people. So you can find some other ways to try to reduce the risk for that individual. And that's part of the process you want to go through. You don't want to simply say, no, we can't do what you're asking. You want to see, is there something we can do to try to reduce the risk to that individual?
David, if I could say too, it can't just be because it's inconvenient or because you grant it to one, 50 other are going to ask for it. All 50 would have to provide the rationale. To go to
That's
a
right.
case that happened a number of years ago, there was a woman who was medically diagnosed with something called seasonal affective disorder, where she needed to be in a room that was well lit, and she had the doctor's notes, and she had all kinds of other issues that stemmed if she was not in that room, and the school said, no, we're not changing you. She ultimately filed a claim, took them to court, and won a $2 million jury award because they wouldn't change her classroom. Now, to be fair, they knocked the jury award down to 100,000 because it was capped, because it was against a district, which was a government entity. But still, you know, if they had simply changed her classroom, that accommodation would have been met. They would have not spent years in litigation, and both sides would have been happy. They would have been able to still, it wouldn't have caused a disruption to the school. It wouldn't have interfered with classwork. I don't even think it was changing floors. It was just changing which end of the hallway she was on. You
Yeah,
know,
yeah,
you've got to be reasonable.
that's
Dave,
right.
Dave, I
Yes.
know you said this, but it's bears repeating that in this particular process, it's only for the actual employee. This is not, I need childcare or I have somebody at home with a compromised immunity. This is
That's right.
something that's just for the employee.
Yes, and we will walk through other rights that are available if it's a family member, but that would not apply in this case. So you have to, under federal law, work through this interactive process. And again, even if you thought the employee was being unreasonable, you want to try to brainstorm other types of accommodations that you could provide for somebody who's at increased risk. So it might be modified PPE, right? You have somebody who is 66 years old, you're asking that person to do screening for people coming into the building. They're at enhanced risk given that job responsibility. You should be making sure that person has a face shield, has a gown, has other PPE. You should be thinking through what are the additional protections we can provide. Frankly, you should do that anyway, because the role that you're asking that person to perform puts anyone at higher risk of contracting the virus. But you want to think about, are there modified PPE requirements that we could put into place as an alternative reasonable accommodation? Or a simple example, you have somebody who is allergic to latex and they are a one-on-one aide who has to work with students. They're at increased risk, and part of the PPE you give that person is non-latex gloves because they need gloves, but the particular ones that you give to others are not going to be safe for this person. So you want to think through those accommodations and think through other ways to mitigate risk. Can we change how somebody performs their job? So, for example, somebody's at increased risk and you ask that person to be the go-to for breaking up fights between kids, and you haven't given that person training on de-escalation strategies. That's not great for the school district, because that basic training would have reduced the risk that the person has to physically intervene, has to physically restrain a student. There's lots of other good reasons to provide de-escalation training anyway, but for this particular purpose, it would reduce the risk. There's no guarantees, obviously, with many of these approaches, but it reduces the risk that somebody has to do something that is a behavior that puts them at risk of great harm. So are there ways that we can make remedial measures more readily available, access to things like hand sanitizer? For somebody who has an underlying issue. Many employees with underlying medical conditions aren't going to necessarily ask to work from home. They're going to ask for some accommodation. Or they might ask to work from home, and that's not reasonable given the undue hardship, but we should be doing something to provide greater protection for that individual. Have we done what we need to do to address things like the district's air ventilation system? Obviously, that's critical for everybody in the building. It's even more critical when you have folks who have underlying medical conditions. Are we using larger spaces so that there's less risk that you have from a small confined area for that employee who has greater risk? We also have to be sensitive. What if a staff member shows symptoms of COVID-19? Every district must have a daily screening process. The Department of Education hasn't been all that specific about how you do this, but you do have to do it on a daily basis. So you certainly want staff members to know the signs or symptoms that they could potentially have COVID-19. A staff member who is exhibiting those signs should not be allowed into the workplace that day. If that staff member is showing those signs and has, very serious health issues they're exhibiting, and it's not safe for them to be able to leave on their own, you may need to respectfully, appropriately isolate that staff member while you're waiting for that person to safely be picked up and transported. So we have laid out, it's kind of beyond the scope of our workshop today, but we have given you a link here to the CDC guidelines for return to work. Once we know somebody was in the workplace and has tested positive, there's a set of very specific criteria to be followed before that individual should be allowed to return to the workplace. And there's various options. One would be 2 negative tests in a row. Another would be a prolonged period of self-quarantine where the symptoms are no longer present. So I encourage you to look at those CDC guidelines for return to work. As a best practice, we do want to make information available to employees. We don't want employees to feel like they can't trust the employer when it comes to asking for accommodations. So we should be providing a notice with the CDC listed medical conditions, who to contact to request a reasonable accommodation, how we begin the interactive process. It's going to be very intimidating for a lot of employees. We should require that request be in writing and supported by medical documentation, again, without forcing somebody to disclose their medical diagnosis. So you always want to go through this process and make sure everyone understands it. At the same time, as we've kind of stressed throughout, HIPAA does apply. So we can't force a staff member to reveal underlying medical conditions. On the other hand, it is a good practice for us to try to gather information. So a voluntary survey to staff to try to determine who might be unable to safely return to the work environment, who might have concerns and want to request a reasonable accommodation, is a prudent step to take for your planning purposes. So we would certainly suggest that districts do that and try to gather information. What we're hearing from districts who have done this is that, there's a sizable percentage of staff members who may have underlying medical conditions and may either not want to return to work or might ask for other reasonable accommodations. So you do have the right, though, as an employer to exclude a staff member if they are showing symptoms currently. Or we're going to get into this, it gets more complicated when we have somebody who's coming from a state on the advisory quarantine list. New Jersey has identified 31 other states on a quarantine list. It's not a mandatory order at this point in time. The advisory applies to anyone arriving from a state with a very specific positive test rate higher than 10 per 100,000 residents, or a 10% or higher positivity rate over a 7-day rolling average. The list is constantly being updated. It was just updated today. So it's a pretty big list right now, 31 states. And by the way, Delaware, for our folks in South Jersey listening, has been added, but the travel advisory does not apply to somebody who is traveling for work purposes. So somebody who lives in Delaware, travels to New Jersey for work, would be exempted from the travel advisory. We do include a link to that list, which again is constantly being updated, a link to frequently asked questions regarding that list from the New Jersey Department of Health. The Commissioner of Health has said, even though it's not mandatory, we expect compliance. So school districts, of course, are expecting compliance as well. If somebody happened to travel to Florida a week before the start of the school year and they're coming back and Florida is still on that list, right now they're on the list, you would expect as a school district for that person to be subject to that quarantine. So we'll walk through how that would work with leave rights in a moment. If you have a family member who's in a high-risk category, the ADA doesn't require that we accommodate that person under the Americans with Disabilities Act, but there are other leave options available. So the Families First Coronavirus Response Act, the Federal Emergency Paid Sick Leave Act, does cover full-time employees. It provides 80 hours of emergency paid sick leave or even part-time employees, the average number of hours they work in a 2-week period, they're entitled to that number of hours of emergency paid sick leave. There are caps on it, which don't apply. You know, most employees are under these caps, but some are not. So if it's because of a quarantine, like the travel quarantine, isolation order, self-quarantine, symptoms, somebody would be entitled to the regular pay rate up to $511 a day. If it's for the care of others, they'd be entitled to a much lower amount, 2/3 of their regular pay, up to $200 per day. Are we still in a state of emergency that would entitle an employee to emergency paid sick leave? We are. Of course, this does get complicated, right? We'll have a staff member who chooses to go on vacation to an area that's considered to be a COVID-19 hotspot, governed by the travel advisory. Now this advisory says you should be home for a 14-day period. Is that staff member entitled to the emergency paid sick leave? Technically, we don't have an order from the state saying that you need to self-quarantine. It's an advisory. But if that employee were to get a medical note from a doctor, that's another way that they're entitled to the emergency paid sick leave. So it wouldn't be difficult, probably, in most cases, for the employee to get that note from a doctor if they tell their doctor they were in one of the states on the quarantine list, which would entitle them to that emergency paid sick leave. We also have other issues. Is your staff member entitled to emergency paid sick leave when their school aide's child's school is closed, their child's daycare is closed or unavailable, their school age child is open, but on certain days the child is receiving virtual instruction and the parent or staff member needs to be home. So it does appear that you would be entitled to the leave for those situations as well. Potentially not for the last one, because technically the school is not closed when we're talking about periods of virtual instruction. We also have the public health emergency added to the FMLA leave. So here the first 10 days of public health emergency leave are unpaid, but under the Families First Coronavirus Response Act, the first 2 weeks that are unpaid under FMLA, the employee could substitute accrued paid leave, including the emergency paid sick leave. So what would otherwise be an unpaid leave could now be a paid leave using either accrued leave the employee has or the emergency paid sick leave. We have also
a cap on the emergency sick leave.
There is.
What's the cap?
So the emergency sick leave has the cap of 500.
I think it's 80 hours.
Oh, 80 hours. Yeah, for hours it's 80.
So it's 2 weeks, and I think it's $511 a day or $517 a day, something like that.
Yep, $511 a day.
Okay.
You also have the temporary disability insurance and family leave insurance that the employee can apply directly for if you have a serious health condition, which is pretty broadly defined under the revisions to the law that went into effect March 25th. So that serious health condition includes an illness caused by an epidemic or communicable disease or a known or suspected exposure to a communicable disease. So suspected exposure, you're in a state that's on that quarantine list, you have a suspected exposure, or efforts to prevent spread of a communicable disease. Again, you're coming from one of those travel advisory states, there would be an effort to prevent the spread of that disease. So you have that serious health condition that prompts the issuance by a public health authority of a determination that would jeopardize others in the workplace, or the serious health condition results in a recommendation by a healthcare provider or a public health authority that the person voluntarily undergoes self-isolation or self-quarantine. So again, probably in order to technically meet that requirement, the individual would need a doctor's note, since the language being used by the state of New Jersey is travel advisory, and you'd want something a little more definitive to say that you've been advised to self-quarantine. It does eliminate the 1-week waiting period for disability benefits. And you do have rights to reinstatement to your prior position. So I want to walk through this and jump to some basic scenarios we have, and then open it up for questions from folks as well. So we have scenarios, somebody has a disability or they're in the CDC high risk category, and they make an accommodation request. We do give you a worksheet that walks through each one of these 6 basic scenarios. So in the first one, the employee would complete a disability accommodation request form, submit that with a physician's certification. You'd go through the interactive process with the employee. If the employee was granted the accommodation, they would be provided with that reasonable accommodation. Let's say it was they were able to work virtually, and that was possible. They would continue to receive their regular pay while they're having that accommodation. If it's not approved because there's an undue hardship on the employer, the employee might be eligible for sick leave under the New Jersey Paid Sick Leave Act, or there might be provisions in a collective bargaining agreement that would provide for paid leave, possibly FMLA entitlement, as we talked about before, depending on the seriousness of the health condition involved. And again, the employers are not required to provide a reasonable accommodation if it causes undue hardship. So these are sort of the basic categories where you might have a request. Somebody is in a high risk category. Somebody makes a leave request for their own health condition, including the fact that they've had a healthcare provider tell them you shouldn't be in the workplace. And certainly that person would be entitled to the emergency paid sick leave or their accrued sick leave in a case like that. Somebody makes a leave request for childcare. Again, we have the family leave options that are available. They make a leave request for the care of a covered family member with a serious health condition. You would have the leave entitlements that they're entitled to. They make a leave request for the care of a loved one who has been quarantined. They would have that opportunity as well. And we talked about the self-quarantining. Again, if it was because of a travel advisory, I think it would be prudent for the employee to also have a doctor's note in that particular case. So each of those I just did quickly because you've got a summary sheet that walks through each of those basic scenarios, and it kind of helps you understand how to think them through. Andy, do you want to maybe talk about some of the, we have a number, we might not get to all of them, but we have 11 other twists on this situation that we could try to talk about. You want to hit this?
Sure. So this is, I trying to recall, rather than doing all of them, which ones are the most pertinent, but I'm just going to go through in the order that we see them, David, if that's all right. So in the first one, we have a principal who's 59 years old. Note the age in each of these scenarios is chosen for purposes of whether it triggers a threshold requirement, legal requirement. So the employee is a principal who's 59. He previously had cancer, but it's now in remission and is otherwise healthy. But, you know, like everyone else, is extremely apprehensive about contracting COVID because of all the unknowns and the complicating cases and factors that COVID contributes to. So the employee requests to work from home, provides something in writing that he or she can work from home, can do most of his or her duties from home, and has no connectivity issues at home. I noticed a typo in all these slides. It's my fault. There should be the word "and" there, but the audience will note that. The employee previously worked from home, like all employees, like I just said. And so the question is, you know, is this employee entitled to any protection under the Americans with Disabilities Act? And I'll sort of open it up to the panel to discuss whether this employee would be entitled to any protections under the ADA, and if not, what other possibilities this individual can utilize.
So you do have somebody who is kind of immunocompromised at this point, who has had cancer. It's in remission, but under the Americans with Disabilities Act, you consider what somebody would be if the cancer was not in remission. And the CDC has said that somebody in this condition is at enhanced risk for severe illness. So from my read, they would be entitled to a reasonable accommodation, and the district would have to go through the interactive process.
You know, that's interesting, because when I wrote this example, I was thinking how, you know, this is an example of a situation where they should be entitled to protections, but I don't think they are, because they don't meet the age requirement, and cancer is in remission and is otherwise healthy. So all you had in my mind was just this person's just generalized fear.
But there is some case law that talks about if a condition of cancer is in remission, you develop the accommodations based on sort of the worst case scenario. So you might not be entitled to implement immediately those accommodations, but the district would still have to go through that interactive process and say, this is our plan if at some point in time you're no longer in remission, and you can't force the employee to wait until then before you go through that process.
Well, I'm happy to hear that, David, because that would be a very crude example. I think this example does illustrate that this person should get the accommodation. I'm happy the ADA would recognize it.
If I can add in there, you can't put the employee at somewhere where they have to, quote unquote, soldier on, to use the court's language from a previous case. In other words, someone that has cancer that's in recovery may have to do extra protections that the rest of the employees don't have to do. Everyone has to wear a mask, but he has to do something more. And the case I'm likening it to was a woman that was a diabetic. She had asked for an early lunch because she had sugar issues. They said no, they gave her a later lunch. And she, even though she was popping the tablets to try to keep her system regular, she ended up passing out in the class and being severely injured. And that was deemed not being reasonable. She shouldn't have to soldier on by popping extra medication. You know, the other analogy I can think of is if your chosen choice of ventilation is going to be opening windows and having a lot of classes outside, and you have someone with severe grass allergies, you can't expect them to pop, you know, a thing Claritin every single day to be able to handle being outside. It wouldn't be fair to subject them to that. That would be my read and analogous to the diabetes case.
Yeah. Good. I think this next example is a good one, Andy.
So we have a 45-year-old administrator who is otherwise healthy, but has a body mass index of over 30. Now, that, you know, I'm looking at the body mass index calculator, and you know, if you have a body mass index of over 30, that doesn't mean you're visibly obese. You know, it wouldn't turn heads if somebody had a body mass of over 30. So there's not a high threshold to reach that. But according to the CDC, having an index of over 30 does place the individual at an increased risk from contracting COVID, and therefore would be covered. So to the extent that this person can produce a medical note and request to work from home and has no connectivity issues at home, would the employee qualify for protections under the ADA? And therefore, would the district have to engage in this interactive process and provide a reasonable accommodation? And I guess I answered the question.
Yeah, I mean, so the answer is that you would have to do that. Now, of course, it might turn out that it's not possible for that person to work from home, that may, because of undue hardship, that might not be the reasonable accommodation, but you'd have to go through this process. And it is a large number of people who would meet that criteria. So you can't simply shut it down and say, no, we're not going to talk about this. You need to walk through the interactive process.
And scenario 3, I think, is a fairly common example that we would have in New Jersey, where you have a relatively young administrator, 35 years of age, healthy, no conditions that would qualify the individual for ADA, but the individual, like everyone else, is nervous, anxious, and concerned about contracting COVID, not just for herself, but because she cares or he cares for his or her parent who does have a compromised immune system and whose parent does qualify for ADA protections. So the employee doesn't want to go to work for that reason, because doesn't want to bring home anything to his or her parent, and requests to work from home and states in writing, again, that he or she can do most of his duties from home and has no connectivity issues. Does the ADA qualify in this scenario?
Yeah, here they would not, because now you're not talking about a condition of the employee, it's a condition of a family member. So now we'd have to look at some of the other leave options that are available to care for another family member. And it would not be something covered under the Americans with Disabilities Act.
So if this individual is so concerned for the safety and well-being of his or her parent, and just decides, I'm not going to go to work, even if the district doesn't provide me with the accommodation that I've asked for, and the district says, okay, well, you can't work from home because we say so, so we're going to force you to use your days, whether they're accrued sick or vacation or personal. Is that legal?
So now the employer is going to be able to require you to use your days or use one of the eligible leave options, and we'll be able to compel you to do that. You're not going to be able to force the employer to say that you're allowed to work from home and have a reasonable accommodation in that case. It just doesn't, that requirement does not trigger under this fact pattern.
And David, aside from this not triggering a reasonable accommodation under ADA, could that person then apply either for the state or the federal family leave to take care of a family member residing in his or her household?
Yes.
Okay.
Yes.
And that would be, you would have to follow the process. You would be entitled to family leave both under federal and state. You could stack them, meaning you could add them to each other, but you don't get paid under the Family Leave Act, correct?
That's correct. That's correct.
And if the employee does have days in his or her bank, and the district just starts deducting from those days, does the employee have any recourse under the collective bargaining agreement? Assuming that kind of thing would be cognizable as a grievance?
Well, if there was some additional benefit laid out in the collective bargaining agreement, they might, but it's hard to envision what the employer would have agreed to that's above and beyond what they're required to do in this case, right? So I'm trying to envision what the basis for the grievance would be.
Just, yeah, I mean, I suppose it's not a great grievance, but the basis could be, in the past, the district has never compelled use of days when the employee is otherwise able to work, even if they're working remotely, and now they are for no real reason.
Sure. So then now you look at the past practice that perhaps was established. So possibly under the collective bargaining agreement, you might have something. But remember, there was a point in time where the governor had ordered a stay at home, except for a very narrow group of essential workers. And that portion of the executive orders was lifted. So the fact pattern has changed now, right? Compared to where we were a couple of months ago.
Let me pose this question, David, or this could also be for Rebecca. I need to stay home to take care of a family member. I can't go in. And I'm being told that I can take family leave, either under the state or the federal. component. Can I use my sick days?
If you're asking me, I'll jump in here on this one.
Sure.
Most of the time that happens, there is so much going on in that person's life that most of the time they end up with a doctor's note that says they're under a great deal of stress handling what's going on, whether it be a relative, a family member, or whatever. And so a lot of times doctors will give medical notes for stress and dealing with scenarios. We haven't had that with this particularly, but that's in general. However, we do have a very timely question, piggybacking off what you're saying. What if after the leave is over for taking care of a parent or a situation, the person just says, I'm not coming in, I'm scared, I'm taking a year leave with no pay. You don't have to pay me, I'll pay for my benefits. What is the job security involved? We had a question about that, and that's come up a lot.
So
In other words,
now you have somebody who potentially that person has abandoned their position. And the employer, if they document that first, you still have rights. Let's say you were a tenured individual and you abandoned your position. There's still a process that the district would have to go through, but there have been cases where abandonment has been the basis for tenure charges.
Those would typically be conduct unbecoming charges for abandonment if they haven't offered any medical reason for going and they just simply stopped showing up. And it wasn't a RIF, it wasn't a layoff.
Well,
somebody that comes right out and says, I've now taken the leave that covers the days to take care of my family, and they could it be childcare if it's in this contract? If, for instance, the child is home and they have to take care of them, their school, they don't want to send them back to school, they're on virtual.
So
I mean, this is not really abandonment, it's just being honest.
In this hypothetical, Rebecca, are we assuming that the individual has like 200 sick days?
No, used up all the days, doesn't have any days left.
No, they used up all their days, no days, and they're being honest. I've used up the leave, I've used up my days, I can't come to work. Either I'm afraid to come to work,
It would
and
seem,
I'm not coming. I'd like a year off. I'd like a leave without pay.
would seem to me, Rebecca, and you tell me if I'm wrong, because you're the Director of Human Resources, it would seem to me that the employee should negotiate something with the district allowing for that to happen. Absent an agreement, there's no way that I would allow my client to take a leave because of the risk of a risk of abandoning the position, that the district would take the position that he or she is abandoning the position. So you need to negotiate some kind of agreement.
And all leaves, Bob, would be certainly on the board agenda for approval, which would be the agreement. But I guess I'm trying to fit it in somebody who is honest and doesn't come up with a variety of doctor's notes or whatever that may or may not be legit. So basically, they do have to have one of the reasons. There is no such thing as I'm asking for a year off.
Yeah, now you certainly under the Family and Medical Leave Act, they get those 12 weeks of leave. The first 2 weeks are unpaid. Then you have 10 weeks where you're paid at 2/3 of the regular rate, up to $200 a day.
That's under the most recent legislation having to do with COVID.
Yes. Yes. So because of that, it gives you some options for those, those 12 weeks, and you could use the emergency paid sick leave for the first 2 weeks, but it doesn't protect you forever.
And David, just so that everybody understands, I don't believe that there's any companion compensation that would come out of the State Family Leave Act. State Family Leave Act is with no compensation, correct?
That's right.
Right.
I would argue too, going back to the abandonment issue, that part of the nexus for doing this in the past conduct unbecoming cases where this has been applied is that there was no justifiable reason for the employee not to appear for work. And that could be a debatable issue over what was justified or what was not. The other thing that will be considered is what was the employer on notice about. So if going with they told them I can't come back because I'm afraid, I don't have anything official, but I'm afraid type of thing, that might slide a bit, as opposed to someone who just says, that's it, I'm done, I'm out of here, I'm not dealing with this anymore. You know, it really, it does become a fact-based scenario as to what exactly happened and what you can prove by what's been documented.
What I was driving at before when I asked the question about can you take sick days if you're taking care of somebody else, and Rebecca said that typically you've got so much going on in the family that you can get a doctor's note saying that you're sick. I just want everybody to understand that the sick leave statute, teachers get 10 days, I believe administrators get 12 days. I think it's in the statute. Actually,
Right.
the statute I think just provides for a minimum of 10. But in any event, it's for when you're sick, and
That's right.
you're not supposed to take it when you're not sick. So the statute limits the use of sick days to when you're sick, and if somebody else is sick, typically that's not going to work unless the somebody else who's sick has made you sick, and you can show that somehow.
Yeah. Now, of course, we do have these provisions for temporary disability insurance when you've potentially been exposed to somebody who has a communicable disease. So you do have some other options available to help you through that situation. But you'd have to show, for the most part, in these cases, that you have some reason to believe that you're dealing with an illness. It's about the employee. It's not about extending the sick days to somebody else in the home being sick. Absolutely. Let me do one more. So here, go ahead, Andy.
Oh, I'm happy for you, Dave. Okay, so the employee is an administrator who's 35, otherwise healthy, suffers no conditions that would qualify normally for a disability under the ADA, but is anxious, concerned, scared about contracting COVID because of the many unknowns about the virus. So in other words, this scenario is everyone.
Yes.
Who just doesn't want to get the virus for their own personal reasons, and requests some modification to the work so that they can work from home, given that this individual can perform most of the duties related to the job at home and doesn't have connectivity issues. So does that generalized anxiety and stress about contracting this new virus qualify for ADA protections? And if you've been listening, the answer is no, unfortunately.
Right.
Maybe I shouldn't say unfortunately, but the answer is no.
That's right. That's right. There's a number of cases that talk about how that sort of generalized fear or anxiety is not going to be sufficient. Now, if you had an underlying mental health condition that's previously been documented and it is exacerbated by what we're going through, which certainly obviously could happen, that's a different scenario. And that may entitle you to reasonable accommodation because that a pre-existing mental health condition is something that's recognized under the Americans with Disabilities Act. But this scenario would cover pretty much, 100% of our employees. I would imagine.
I would say the scenario David described would require actual documentation.
That's right.
It's not merely calling up and saying, I'm worried, I don't want to come in. It's the same as just saying I'm depressed or I'm sad. It's not sufficient to get the ADA qualification. You actually need medical substantiation to do that.
That's right. And it has to be not just a condition, but that it substantially limits your ability to do the job. There are lots of folks who have, anxiety, depression, who are functioning very well in their work environment. So Rebecca, what we will do as a follow-up to today is sort of put together some bullet points on each of these 11 scenarios. So we'll do that as a follow-up for all of our participants. But do we have other questions, Rebecca?
Yes, we do. There's one for Andy. Andy, they noticed in all your scenarios that you very clearly mentioned has no connectivity issues. Up to now, I don't believe a lot of us have even asked that. Is that something that legally is important to be in their documentation?
I don't think having connectivity triggers any particular statutory requirement, but I think it's important to put that in the documentation only because it would telegraph to the district that notwithstanding you can do the work from home, you've got you've got access to technology at home. You've got access to a place where you can do the work, where there's uninterrupted service. I don't think that triggers a particular legal requirement, but I think it's a matter of practice and just for the practicality of it. I think indicating to the district that you've got a great internet connection, and you've got all the technology at home. I think is just important, just so they know that you can do the work. Because one of the issues that the closure brought to light was the severe connectivity issues, and obviously the connectivity issues at that point related mostly to students. I know that schools did survey the students about connectivity, and I added it. The answer to your question is I don't think it triggers any particular statutory requirement, but I think it's important as a matter of practice.
The only thing
I
I
would say,
the one thing I would say is that you would perhaps look at it. Let's say the person didn't have good connectivity. Now the employer, as part of their reasonable accommodation, might be trying to address that issue as well for somebody who's otherwise in need of a reasonable accommodation and could work from home. And you'd have to do an analysis because, maybe the employer says this is so expensive or difficult, it's an undue hardship, but I doubt it. It doesn't seem like that would be such a big hurdle to overcome to help.
That's a very good point. That's a very good point. It would limit their burden on the reasonable accommodation analysis.
Yeah.
Now, that's an excellent point because we haven't seen that previously. I haven't, and a lot of people haven't. The other comment, it's not a question. I know a couple of you have written that you had trouble downloading the guidance on the ADA. All of these materials, as well as the PowerPoint, will be sent to you by tomorrow. So don't worry, you didn't miss out. And we had one other question that came up about breaking up the Child Care Leave Act. In other words, your child is only going to school in a hybrid model, 3 days a week. Are you allowed to request the act and take it for 2 days a week when the child's not in school?
You're allowed to intermittently, use the leave options that we have available here. It doesn't have to be all consecutively.
Thank you.
Yeah. So as we are wrapping up, I think many of you know this, but we have lots of great resources on our website that have tried to help you through these last several months. So we give you a link here to a number of our other webinars that we've offered and a link to lots of other free workshops that we have offered on our website. Closing comments, Bob, any thoughts as we're wrapping up?
We're in new territory, and this interactive process, I think, is going to take on added importance, and documentation is going to be the key if you want an accommodation. I'm expecting that beginning next month, we're going to be seeing a slew of people ask for accommodations for a variety of reasons, whether it's because they're in the high risk category, or because they're taking care of people who are in the high risk category, or because of childcare issues, or there's going to be a whole slew of things out there, and we're going to have to deal with that. And I would just strongly recommend to anyone who's asking for an accommodation that before you go ahead and submit the request, that you speak to one of us and try to get some direction.
Yeah, you want to know your rights. You want to understand the process. So part of what we're trying to do here is to make sure everybody understands that. And, from the employer perspective, you want to build that trust with all of your employees and be really transparent. Let everybody understand what the process is. It can be very intimidating. And in many ways, it can help everyone if we build that trust. And we can get very creative with accommodations. There's lots of possibilities when you start working together with the employees. Rebecca, any final thoughts?
Yes, first of all, we had a couple, and I'm thanking all of you. This is an extremely, extremely difficult topic. There's so many legalities, there's so many new leaves, and so many different ways to take different leaves. So they all just wanted to thank you, and we thank you. It's been a fabulous, fabulous topic, and one that's very, very sorely needed.
Sandra, any thoughts as we're wrapping up?
just to follow up on Bob said, trust but verify. Going back to anyone who's ever taken anything I've ever given is, if it's not in writing, it did not happen. So you need to make sure your documentation is in order that confirms the phone calls you had. Save those emails somewhere. Have everything that you can show in writing exactly what you did or did not do, or what you were able to do or not do.
Absolutely. And Andrew, any final thoughts?
And again, in terms, I just want to add this, in terms of the
Oh, go ahead. Sure,
accommodation,
bud.
in terms of the accommodation, the more you have, the more documentation you have, the better.
Yes. Yeah, no question.
Sorry.
Andrew?
Yeah, I would just
Sure.
echo the comments that Bob, Sandra, and Rebecca and David, of course, have made. And you know, the comment about contacting PSA, it's very important, because once you submit the request, if you change the request later after speaking to an attorney or after speaking to somebody else, that could potentially undermine the request, because the question they're going to be asking is, why is this changing? It shouldn't be a moving target. So you really want to get it right from the start. So please give us a call.
Yeah, and of course, you know, I think the vast majority of you happen to be PSA members. If you're not, yeah, reach out to an attorney. It is important for you to know your rights in this process. And the more that we can recognize those rights and work together, you know, the better off we're all going to be. This is a difficult time for everyone. The fear is real, the anxiety is real. But there's lots of support out there, and we have lots of new legislation that does provide some additional protection. And it's important that everybody understand all those different options that we have. So thank you, everybody. We know what incredible work you're all doing in the field, and we just want to be here to support you along the way. Thank you so much for everything that you're doing. And we do have additional webinars coming up the next 2 weeks on other aspects of reopening. So a week from today, we're going to be talking about issues related to buildings and grounds and transportation. And the week after that, about working with parents linked to reopening. And we also have roundtable discussions for NJPSA members of our next 3 Wednesdays addressing these important issues. So we encourage folks to sign up for that as well. Thank you, everybody, and we look forward to seeing you at a future session.
Thank you,
Thank
David.
you, David, and
Bye-bye.
thank you.
Thank you, Dave.
Thank you.
Thanks, everyone.